Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're hearing on case 1 CR23-0313, State versus Bojorquez. Each side will have 20 minutes to present their argument. So you may save as much time as you want for rebuttal, but you'll have to keep track of your time. That's why we have a clock at the podium. And you do have to use all of your time. If you think you've adequately presented your case, you can sit down. We recorded the argument both in audio and video. When it's your turn, please identify yourself and your client, so when we review that, we can keep everybody straight. The video will be on YouTube in a day or two, so you can see how well you did. We've read the briefs and conference the case. We understand the facts of the issue, so when you begin your argument, you just launch right into what you'd like to talk with us about. Counsel, you may begin.
Good morning. May it please the court. My name is Robert J. Campos, and I represent petitioner Alejo Alvarez Bojorquez. Mr. Bojorquez requests that this court accept jurisdiction and grant relief, namely that the case be remanded back to a new sentencing court. This court is also asked to render a published opinion requiring that sentencing courts in the future state specifically on the record the aggravating and mitigating factors the sentencing court finds when pronouncing the sentence, even in cases where the sentencing court gives the presumptive sentence.
I appreciate that argument, but that goes counter to, I couldn't tell you how many decades of law.
Exactly, Your Honor. Currently, I agree that Arizona law does not require that sentencing courts specifically state on the record the aggravating and mitigating factors found before handing down a sentence.
Well, but what's your statutory or constitutional basis for requiring that?
Our Supreme Court in State v. Harrison affirmed the analysis of State v. Holstrom. And there, our Supreme Court stated, the victim, the defendant, and the public have the right to know why a particular sentence was imposed and that it was not arbitrary. These interests are not satisfied simply because an appellate court is able to infer what the judge might have thought.
But isn't there a distinction in that language, between a presumptive sentence and one that departs from that presumption?
I agree, but the court goes on, and I think this is what's critical. It says, requiring the judge to tell the victim, the defendant, the appellate court, and the public what he or she considers as aggravation and mitigation, and why he or she imposed an aggravated or mitigated sentence is important.
But when you get the presumptive sentence, then what's aggravating and what's mitigating don't really matter.
I agree. There's a void. The state's position has been that since my client received the presumptive sentence, it doesn't really matter what aggravating or mitigating factors the court found. I think that's an invalid argument. For example, under this theory, a sentencing court could state it does not like the defendant's brown eyes, but loves his polished black shoes. The court then sentences my client or a client to the presumptive sentence.
Well, but counsel, I understand the point you're making, but those are improper and irrational
Exactly the point.
factors.
Exactly the point in our case, Your Honor. What I raised was that the court impermissibly considered my client's lack of remorse, impermissibly considered my client's lack of acceptance of guilt, and impermissibly...
How do you support that? The court found no remorse as a mitigating factor. That's not the same as considering lack of remorse to be an aggravating factor.
Judge Kiley, I respectfully disagree. I read and reread what Judge Lemire said, and frankly, I could not tell what factors she considered aggravation and what factors she considered mitigation.
But we know she didn't find any aggravating factors to bump the sentence up to an aggravated sentence, right?
I would disagree, Your Honor, and
Let me rephrase that. She did not impose an aggravated sentence.
I would disagree. I would disagree
Okay.
because my client, under the plea agreement, had an option to be sentenced to probation. So in my client's case, being sentenced to prison was frankly an aggravated sentence.
The probation was for the other counts, not for the count at issue.
Correct.
So it's not right to say, even if you could in a given circumstance, that a presumptive sentence is an aggravated sentence.
My client pled to 3 counts. On 2 of them, it was stipulated probation, lifetime. On 1 count, it was a no agreements. So the court was free to sentence a petitioner to probation. So under the facts of this case, I would respectfully disagree. And I would argue that in this particular circumstance, imposing prison on a 70-year-old man was a aggravated sentence,
So
and the
are you
court had
saying
the
that
option to probation.
If probation is available, then the presumptive sentence is no longer the presumptive sentence? Is that what you're saying? That it, by definition, becomes an aggravated sentence?
No, I'm saying in this particular case where you have the option to sentence a petitioner to probation, that a court sentencing the petitioner to prison, in fact, as a practical matter, is an aggravated sentence.
But Counselor, I don't mean to get too technical, but probation is a suspension of a sentence. It's not it's not a sentence in and of itself. So it's odd to say that probation is in this circumstance a presumptive or a mitigated sentence, however you want to term it.
Well, I agree, Judge Howe, but in this particular case, as a practical matter, sentencing the petitioner to prison was an aggravated sentence under the deal that he negotiated with the state.
It's aggravated colloquially speaking. It's not aggravated legally speaking, and that's what we deal with.
Another issue I think the court needs to consider is whether or not Judge Lemire impermissibly used her own personal experience when she presided over the sentencing and made the statement that based on her experience, there was likely that candidly she thought that there might be other victims. I think that's very problematical also. So I think an argument can be made that Judge Lemire used some correct factors in sentencing petitioner, but at the same time, she inserted a factor that was clearly not supported by the record, and she impermissibly injected her own personal bias that in these sex cases there must have been additional victims. And she said candidly,
Let's assume I agree with you, and that her statement was impermissible and that it evidenced some bias. Hypothetically, I agree with you on that. Outside of that factor, was there nonetheless still sufficient information and evidence in the record to support a presumptive sentence.
I don't believe so, but you also have to take it into context. I believe she also said that my client lacked remorse and didn't accept responsibility. That's what I got from what she said.
But he didn't accept responsibility.
He gave a mixed bag when he made his statement before the court.
Can you point me to somewhere in the record where there is an unequivocal or a clear demonstration of remorse?
He says, I am sorry. At the same time, I agree, he makes a statement alluding if he committed the crime.
He also submitted the polygraph results, evidently to support a claim that he was actually innocent. Isn't that right?
Correct. But under state truth, let's assume like the petitioner stated, I am not guilty and I have no remorse. Under State v. Trujillo, the court still could not have accepted those as aggravating factors.
But there's nothing in the record that says that the court found that as an aggravating circumstance.
I agree. And that's the whole crux of the issue here, is that we now have to try to untangle what was, in fact, an aggravating factor, what was, in fact, a mitigating factor.
Then, Counsel, I'll return to one of my earlier questions, and if I didn't recognize that you answered this, what is the statutory or constitutional authority for requiring a court to state on the record its findings on the aggravating and mitigating circumstances when it imposes a presumptive sentence?
I don't believe that there's any Arizona law currently that mandates that a court specifically state on the record the aggravating and mitigating factors. I agree. But I believe that this case is a perfect vehicle for this court to remedy an issue that repeats itself. I practiced 37 years, and I've been in front of many very good judges, thousands of sentencings. Good judges will give their speech, but at the very end, they will be very practical and forthright and precise, and then state, I find these are the aggravating factors, I find these are the mitigating factors. I find aggravation outweighs, or I find mitigation outweighs, therefore I'm imposing the following sentence. Even when they give the presumptive sentence, good judges will state on the record both aggravating and mitigating factors. That way, everybody knows exactly why the court imposed the sentence that it did. So I agree, Judge Howell, that there is nothing currently in Arizona law that requires a sentencing judge to do this.
Then if that's the case, then how can we find error? We can't. Because all this court can do is apply the law. And the law, as you admit, the law doesn't require that, so isn't that the end of the story? Aren't you better served petitioning to the Supreme Court to make a rule change or go to the legislature and have them change the law?
Okay. What I'm saying is currently Arizona law does not specifically require it, but there's nothing that prevents this court from issuing an opinion stating that in the future, to alleviate confusion, sentencing courts must state on the record aggravating and mitigating factors. I don't see anything that precludes this court constitutionally from requiring that from superior courts. Currently, superior courts give defendants a Donald advisement. And Donald was a case, a PCR case where the defense attorney did not properly advise the defendant about the repercussions if the defendant went to trial and lost. Courts now routinely, in every case, require the prosecutor to stand up and give a Donald advisement, advising the defendant of what he's facing if he rejects the plea offer and goes to trial and loses.
But that wasn't from our court, that was from the Supreme Court, and I think there was a constitutional basis.
Correct.
For that.
My point is that it's not burdensome to require a sentencing court to state specifically what it finds as aggravating and mitigating factors, just like it's not burdensome to ask for a Donald hearing when a defendant is rejecting a plea agreement. I do want to emphasize Munninger, the case that I cited in my brief. I believe that the record is very clear that the court used her own personal bias, that there might be other victims as an ingredient when she was sentencing my client. And under Munninger, our position is that once she spoiled this cake, that it doesn't matter that the rest of the ingredients were fine. Munninger holds that once the court uses a sentencing consideration that's unlawful, that you cannot parse then what the court would have done had it not considered that illegal sentencing requirement.
Well, despite the court's observation, the court made no finding of multiple victims as an aggravating factor, and we know that because there was no aggravated sentence imposed. Isn't that right?
Again, I believe that in this particular instance, when a defendant has an opportunity under the plea agreement to get probation, and that's what they're hoping for, that's the basis of the bargain, that when a sentencing court sentences a defendant to prison, that the court should state on the record why it's doing that, and should state what it finds as aggravating and mitigating factors. I have read and reread what Judge Lemire said, and I cannot honestly tell this court what was an aggravating factor and mitigating factor. At best, I will give Judge Lemire that she did find that there was harm to the victim in all of that. I believe that can be pulled out of there. But we should not have to guess as to what her thought process was. I also want to reiterate that Judge Lemire had two opportunities to clarify the record. The trial attorney filed a motion to resentence the client, vacate the sentence. Judge Lemire issued a minute entry and again didn't state her factors. When Judge Lemire denied our initial PCR, again, Judge Lemire did not state what factors she took into consideration. So I don't believe it's burdensome to ask courts to be clear. I don't believe that the Constitution prevents this court from asking judges to be clear when they sentence a defendant. I see that I have about 4 minutes left. I'd like to reserve my time for rebuttal.
Sure.
Thank you.
Thank you, counsel.
Good morning. May it please the court, Christine Davis with the Maricopa County Attorney's Office on behalf of Respondent, State of Arizona. Your Honors, I'm actually not going to use much of the time at risk of returning it to the court for lunch or other tasks, mainly because the questions that the court had for petitioner are largely the arguments that I would have made, and I think largely absent your questions, that the state can rest on the briefing. What I will say is that what I'm hearing argued is for law and policy changes at a sentencing hearing. And I think we have to be very careful to consider what we're here for today, which is not a de novo review of a sentencing hearing, not a direct appeal, certainly not a legislative hearing on a rule change or change of law. What we're here for is the denial of a petition for post-conviction relief. And the standard, what has to be shown to this court, is an abuse of discretion. And I haven't heard that argued. I didn't read it in petitioner's briefings that Judge Lemire abused her discretion in denying the petition for post-conviction relief, which really is the narrow inquiry for this court.
What would you say is the significance of the sentencing judge's reference to the potential for other victims?
I would say that was inartful. And, you know, we don't get perfect sentencing hearings in criminal cases, perhaps in any kind of case. We don't get perfect hearings. But judges are permitted to bring their experience to the table and aren't expected to be a blank slate slate. So I think her comment, again, while inartful and perhaps not a best practice in a sentencing hearing because it led us here today, I don't think legally it rises to the level of what this court has described as actual bias or an abuse of discretion. I think she was expressing her knowledge of general sex offender statistics and principles, and actually if you look at Judge Lemaire's biography, her biographical information, which petitioner included as an exhibit, she indicated on the record she had 17 years in juvenile courts, and had some experience with sex offenders and child molesters, but, she was functioning as a criminal defense attorney during that time. So I don't think there's even an argument, that, this is a former sex offender prosecutor who, was very clearly biased. I just don't think the record shows it, and I don't think that we require our courts to be a blank slate.
Let's assume for the moment, and I'm not asking you to agree that this is what she said, but let's assume for the moment that her statement was more clearly or more appropriately characterized as her saying, I believe there to be additional victims. Wouldn't we perhaps be in a situation then of having an abuse of discretion on the question, the specific question of bias, that there's really no way to parse out how much that weighed in on the sentencing because the court was explicitly taking into account the presence of victims not before the court?
I think under that scenario, you might have more of a problem here, except for the fact that she imposed the presumptive sentence, which I think would indicate, even with that stronger language, that she wasn't finding her belief in the likelihood of other victims to be an aggravator.
Okay.
I
take it you reject, and I would have expected you to, but maybe you can respond directly to your colleague's argument about in this particular case, this amounted to an aggravated sentence given the availability of a probation only.
I just don't think there's anything in the law that supports that. This was a no agreements plea on that particular count. There were 3 different settlement conferences in this case. The defendant was well aware of the exposure. And I don't think there's anything in the law that says if you stipulate to no agreements and you could get probation, that, if you're of a certain age or you have certain health issues, that instead if the court imposes prison, which again you agreed to, that's an aggravated sentence. I just don't think that's supported under current law.
Probation is not a sentence, is not the sentence of the law, is it?
Correct. It's a suspension of sentence. Yes. And unless the court has other questions for me, I surrender my time.
No. Thank you, counsel.
Thank you.
You have time for rebuttal.
I just want to reemphasize one point that I think has been lost, and that is Judge Lemire made a finding that my client lacked remorse. She made a finding that he did not accept guilt. And under Trujillo, it's an abuse of discretion for a sentencing court to consider lack of remorse and lack of acceptance of guilt.
As an aggravating circumstance.
I think as a factor at all in sentencing, I think a defendant has a right to stand up and say, I'm innocent.
Well, didn't she preface the remarks that you just referenced? Didn't she preface that with the statement, I had been considering a mitigated sentence, however, I don't find mitigation because there is no real remorse. Isn't that what she said?
She started out with, candidly, I was considering a mitigated sentence, but then she says, candidly, I was concerned about potential other victims. I don't know how that can be ignored. I think that ruined, as I say in my brief, the cake. Once that ingredient was tossed in there, it doesn't matter that she used all the other correct ingredients. The cake was spoiled. Mr. Bojorquez received an illegal sentence. The court abused its discretion in using that factor. I don't think the record clearly indicates that she did not use the possibility of other victims as a factor. you take her words at face value, and the court is clearly stating, based on my experience, I believe candidly that there may be other victims out there. And that's what changed her mind.
In a given case, the court can consider remorse as a mitigating circumstance.
Yes.
But for it to do so, it has to make a finding on that. It seems like you're saying that by not finding it a mitigating circumstance, that's necessarily error.
What I'm saying is it was very unclear what factors the court was finding. But it looked clear on the basis of what Judge Lemire said that she was biased because based on her previous experience, she felt that there must be other victims and that she candidly was considering a mitigated sentence until she came to the conclusion that there might be other victims, which was not supported anywhere in the record by the police reports, the pre-sentence reports, the prosecutor statements, nor the victim statements. So our position is that Judge Lemire abused her discretion, and even if this court believes that it cannot order courts to state specifically on the record aggravating and mitigating factors, I still believe that this court cannot ignore the fact that this cake was ruined by Judge Lemire adding the ingredient of the possibility that there were other victims out there that had not come forward. So I believe just with that statement alone, this sentencing was unlawful and that Judge Lemire abused her discretion.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.